High Court. The High Court stands at the head of the judiciary in a state. There shall be a High Court for each state. Article 214. The judiciary in the state consists of a High Court and the subordinate courts. The Parliament can, however, establish by law a common High Court for one or more state or states and one or more union territory under Article 231 231 के तहत. Every High Court shall be a court of record. Article 215. The High Courts in India find their roots in the British period when three High Courts, namely Bombay, Madras and Calcutta, were set up in 1862. Now, qualifications of judges. The qualifications required under the constitutions for a person to be appointed as a judge of the High Court must be a citizen of India, must have held a judicial office in the Union in the territory of India for at least 10 years, or must have been an advocate of a High Court for two or more such courts in succession for at least 10 years. Appointment of the judges. Every High Court consists of Chief Justice and such other judges as appointed by the President from time to time. Article 216 के तहत. The Constitution, unlike in the case of Supreme Court, does not fix any maximum number of judges for a High Court. High Court के लिए fix judges नहीं है, ठीक है. Then, apart from appointing the judges of the High Courts, the President has the power to appoint additional judges for a temporary period not exceeding 2 years for the clearance of arrears of work in a High Court. An acting judge, when a permanent judge of a High Court other than Chief Justice is temporarily absent or unable to perform his duties, or is appointed to act temporarily as a Chief Justice. Then, an acting judge hold office until the permanent judge resumes his office. Neither an additional nor an acting judge can hold office beyond the age of 62 years, now 64. Okay. While appointing a judge of a High Court, the President is to consult the Chief Justice of India, the Governor of the state, and the Chief Justice of that High Court in the matter of appointment of a judge other than the Chief Justice. Removal of judges. Removal of a High Court judge is governed by Article 217, 1B and Article 218 of the Constitution on the ground of proven misbehavior or incapacity. The words misbehavior or incapacity have neither been defined nor clarified in the Constitution. The complaint about misbehavior or incapacity about a judge has to be probed under the Judges Inquiry Act 1968. Judges Inquiry Act 1968. Then, transfer of a judge between High Courts. A judge of a High Court can be transferred without his/her consent by the President under Article 222. Consultation with the Chief Justice of India must be done. All relevant facts related to transfer of a judge of a High Court must be provided to the Chief Justice of India. The opinion provided by the Chief Justice shall have primacy and is binding on the President. Now, Justice Sumitra Sen case. Justice Sumitra Sen of Calcutta High Court was held guilty of misappropriation of public funds on 19th August 2011. The Rajya Sabha voted in favor of impeaching Calcutta High Court Justice Sumitra Sen. Then, Justice Dinakaran case. Justice P.D. Dinakaran had huge assets and land acquisitions in his hometown Arakonam, more than what was fixed by the Tamil Nadu land reforms. In 2009, the chairman of the Rajya Sabha admitted a motion seeking his removal on charges of corruption and abuse of his judicial office. Facing impeachment on charges of corruption and judicial misconduct, he resigned before the proceedings could complete, expressing lack of faith and confidence in the three-member inquiry committee probing charges against him. Thank you.